threw out a judicial decision rejecting Donald Trump's bid to shield himself from federal criminal charges involving his efforts to overturn his 2020 election loss in a major ruling on Monday involving the scope of presidential immunity from prosecution. The court ruled that former presidents are shielded from prosecution for actions they take within their constitutional authority. Trump is the Republican candidate challenging Democratic President Joe Biden in the November 5 U.S. election in a rematch from 4 years ago. The court's slow handling of the blockbuster case already had helped Trump by making it unlikely that any trial on these charges brought by special counsel Jack Smith could be completed before the election. Trump had argued that he is immune from prosecution because he was serving as president.
What I am about to walk you through is the single most consequential constitutional ruling of the modern era, and the story is still actively developing in ways that most people have completely missed. On July 1st, 2024, the Supreme Court of the United States handed down a ruling in Trump v. United States that changed the legal landscape for presidential accountability forever. 6 justices against 3, strict partisan split, and the ruling established something that had never existed before in the entire history of American constitutional law: a formal framework for presidential immunity from criminal prosecution. But here's what most people got wrong about that ruling. Both sides got it wrong in opposite directions. Trump supporters said it was a total victory that made him untouchable. Critics said it was a license for presidents to commit crimes. The truth, the actual documented legal reality, is far more complicated and far more interesting than either of those takes. Because what the court actually said was this: presidents have absolute immunity for core constitutional acts, presumptive immunity for official acts, and no immunity.
If such actions were official conduct, Trump's lawyer argued, a former president could be charged only if first impeached by the House of Representatives and convicted in the Senate, something that has never happened in U.S. history. In a May Reuters, Ipsos poll, just 27% of respondents, 9% of Democrats, 50% of Republicans and 29% of independents, agreed in an insurrection by inciting and supporting the January 6, 2021, attack on the U.S. Capitol by his supporters. The timeline of the court's immunity ruling likely does not leave enough time for Smith to try Trump on federal election subversion charges and for a jury to reach a verdict before voters head to the polls. Trump took numerous steps to try to reverse his
immunity whatsoever for unofficial acts, and the question of what counts as unofficial, the question of what conduct falls outside the protection of that ruling, is a question that courts across the country are right now actively fighting about in live cases, including cases involving Trump himself, including a brand new Supreme Court petition that was filed in May of 2026, just days ago, where Trump's legal team is trying to extend the immunity ruling to cover conduct that happened after he left office and that the ruling itself never addressed. This is wild. Can you believe this? We are right in the middle of this constitutional story right now. And today, we are going through every piece of it: the ruling, the framework, the dissent, the ongoing cases, and the newest developments, so you understand exactly where American presidential immunity law actually stands in 2026. But before we go any further, real quick, let's be honest, you can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video. So here's where we are right now and why it matters urgently. The Supreme Court's 2024 immunity ruling explicitly addressed what happens to a president's immunity for official acts taken while in office. But it left a critical question almost entirely unaddressed. What about conduct that happens after a president leaves office? What about statements a president makes as a private citizen after the presidency ends that are then used against him in civil or criminal proceedings? What immunity does the ruling provide for that post-office conduct? And right now, as of May of 2026, Trump's legal team is preparing to bring that exact question back to the Supreme Court in the context of his E. Jean Carroll defamation cases where Trump made statements about Carroll after his first term ended, statements that a jury found defamatory and that have so far resulted in judgments totaling nearly $90 million against him. And Trump's lawyers are going to argue at the Supreme Court that the immunity reasoning from Trump v. United States should extend to protect at least some of that post-office conduct. Are you kidding me? The immunity ruling that everyone thought was settled is about to generate a whole new round of Supreme Court litigation about its scope, and the outcome of that litigation will determine not just whether Trump has to pay $90 million to E. Jean Carroll, but what kind of legal protection every future president and former president has for everything they say and do after they leave the Oval Office. That is the stakes. That is why this story matters right now, and that is what we are going through today in complete detail. So stay right here. because part 2 is where we go all the way into what the 2024 ruling actually said, what it left open, what the dissent said, how courts have been applying it, and what the new post office immunity fight is actually about. The full picture. No shortcuts. Let us get into it. Alright, let us build the complete picture of where presidential immunity law actually stands right now, because most coverage of this topic has been either cheerleading from one side, catastrophizing from the other, and almost none of it has given people a clear, accurate, complete understanding of what the Supreme Court actually said and what it actually left open. So let us go through this carefully and completely, because every detail matters. We start with what the court actually decided in Trump v. United States. The case reached the Supreme Court after the D.C. Circuit Court of Appeals in a unanimous 3-judge ruling held that Trump had no immunity from criminal prosecution for his alleged efforts to overturn the results of the 2020 election. The Supreme Court granted certiorari and fast-tracked the case, oral arguments in late April of 2024, decision on July 1st. And Chief Justice John Roberts wrote the majority opinion for 6 justices himself, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. The framework he established has 3 tiers. Tier 1, core constitutional powers. Things like the pardon power, the power to direct the Justice Department, the power to remove executive officials for presidential conduct in these areas. The court said immunity is absolute, period. No prosecution, no exceptions, under any circumstances. Tier 2, other official acts. Things the president does in his capacity as president that do not fall into the absolute core category. For those, the court established presumptive immunity, meaning prosecutors start from behind and have to overcome a strong presumption that the conduct is protected. That is an extremely high bar to clear. And Tier 3, unofficial acts. Private conduct, things done as a private citizen and not as the president. For those, the court was explicit. There is no immunity. The full force of criminal and civil law applies exactly as it would to any other American. Those are the 3 categories. And the question of which category any specific conduct falls into is the question that courts across the country are now being asked to answer in case after case after case. Now here is what the court specifically decided and what is specifically left open, because this is where most coverage has been imprecise. The majority ruled on 2 specific aspects of the charges in the Jack Smith indictment. First, Trump's alleged interactions with Justice Department officials about the 2020 election results. The court held those were absolutely immune. Directing the Justice Department is a core presidential power, period, protected. Whatever Trump allegedly told DOJ officials to do in connection with the election, courts cannot touch it. Second, Trump's alleged pressure on Vice President Pence to reject electoral votes. The court held those were presumptively immune, meaning prosecutors would have faced a very high bar to use any of that as evidence. And everything else, Trump's contacts with state officials, private individuals, members of the general public, the court sent back to the lower courts to be evaluated on a case-by-case basis under the official act versus unofficial act framework, which means years of additional litigation to determine what is prosecutable and what is not. Come on. The most significant immunity ruling in American constitutional history, and it resolved 2 specific questions while sending everything else back down for further proceedings. That is the real outcome of Trump v. United States. Not total victory, not total defeat, a framework that shifts the battlefield to lower courts and guarantees years of continued litigation. Now let us talk about the dissent. Because the 3 dissenting justices, Sotomayor, Kagan, and Jackson, did not accept this framework quietly. Justice Sonia Sotomayor wrote what legal scholars have called one of the most urgent and consequential dissents in the modern history of the Supreme Court. She wrote that the president is now a king above the law. She laid out hypothetical scenarios that went viral immediately after the ruling dropped. What if a president orders the military to assassinate a political rival? What if a president accepts a bribe to issue a pardon? What if a president organizes a coup, arguing that under the majority's framework, these actions could potentially be shielded by claims of official authority? She said the majority failed to seriously grapple with any of those scenarios. Justice Ketanji Brown Jackson wrote separately that the ruling creates a law-free zone around the president, a space where criminal law simply does not function. And she pointed out that the founders never wrote presidential immunity into the Constitution, and that the fact Gerald Ford felt he had to pardon Richard Nixon after Watergate proves the system always assumed presidents could be criminally prosecuted. You do not pardon someone who is immune. That is a foundational constitutional observation. And it sits in the permanent record of this case as the dissent's most powerful argument. Are you kidding me? 3 Supreme Court justices calling the ruling indefensible and comparing the president to a king. That is where the court was on July 1st of 2024. And that divide between the 6-justice majority and the 3-justice dissent has not gotten smaller in the 2 years since. It has gotten more consequential. Now here is where things stand in 2025 and 2026, because the immunity ruling was not the end of the story. it was the beginning of a new and even more complicated phase. In the immediate aftermath, federal charges against Trump related to the January 6th events and the 2020 election were effectively dropped. Trump won the presidency in November of 2024, returned to the White House, and the Justice Department, which does not prosecute sitting presidents, dropped the Jack Smith cases. So the specific criminal context that produced the immunity ruling is gone. But the ruling itself remains as settled constitutional law applicable to every future president, and being actively invoked in civil cases in ways the majority opinion may not have fully anticipated. The most immediate and most consequential civil application is in the E. Jean Carroll cases. A federal appeals court upheld the $83 million defamation judgment against Trump in September of 2025. Trump has a Supreme Court petition pending in that case asking the justices to review the verdict. And as of May 6 of 2026, Trump's legal team announced they are preparing to file a second Supreme Court petition in the Carroll litigation. This one specifically focused on presidential immunity. The argument Trump's lawyers intend to make is that the statements Trump made about Carroll, statements he made while he was president during his first term, should have been protected by the immunity ruling as official presidential conduct. The reasoning is that a president commenting publicly on matters that affect his reputation in his capacity to govern falls within the outer perimeter of official presidential responsibility. Carroll's legal team has fiercely disputed that framing. They argue Trump's statements about Carroll were personal attacks made in his private capacity as a defendant in her lawsuit, not official acts of the presidency. And the courts have so far agreed with Carroll, but Trump is going to the Supreme Court again with the immunity argument. In a civil case, for post office conduct, and if the Supreme Court agrees to hear either or both of Trump's Carroll petitions, the justices will be asked to extend their 2024 immunity framework into territory. The original ruling explicitly left ambiguous that extension, if it happens, could have enormous consequences for every future president and former president facing civil liability for things they said or did in office or in the transition between terms. And there is another layer that makes all of this even more significant. The Brennan Center for Justice, one of the most respected constitutional law organizations in the country, published analysis in 2026 calling the immunity ruling unfounded in both history and legal precedent and arguing it poses a serious risk to the system of governance. A Penn Law Review article published in March of 2026 engaged in deep analysis of the ruling's separation of powers implications, examining how Roberts defined the outer perimeter exclusive presidential authority, and arguing that if the definition is interpreted broadly enough, it could encompass a vast array of presidential conduct that most Americans would consider clearly subject to accountability. These are not fringe legal voices. These are mainstream constitutional scholars publishing in peer-reviewed law journals, raising fundamental questions about whether the immunity framework the court established is sustainable and what its long-term implications for democratic governance actually are. And those questions are going to be answered in the courts, in Congress, and eventually in future Supreme Court decisions over the coming years and decades. The immunity ruling opened the door. What walks through that door is still being determined. Okay, let us bring this all the way home right now. 4 completely developed, honest points that give you the complete picture of where presidential immunity law stands, why it matters urgently right now, and where this entire story is heading. Point 1. The 2024 immunity ruling was transformative, but deliberately incomplete, and that incompleteness is the source of all the ongoing legal conflict. Here's what the court actually decided and what it intentionally left for lower courts to resolve. Because this distinction is critical for understanding why the immunity battles are still ongoing and why they are going to continue for years. The court established the 3-tier framework: absolute immunity for core acts, presumptive immunity for official acts, no immunity for unofficial acts. It applied that framework to 2 specific factual questions in the Jack Smith indictment and resolved those questions. And it sent everything else, every other specific factual question about what counted as official and what counted as unofficial in Trump's alleged conduct, back to lower courts for resolution. That remand was a choice. The majority could have tried to draw clearer lines. They chose not to. And that choice means that every disputed question about whether a specific presidential act is official or unofficial has to be litigated from scratch in the lower courts under the framework the majority established, which is exactly what is happening right now in the Carroll cases in the hush money appeal. In any future civil or criminal proceeding involving Trump or any other former president who invokes the ruling, the incompleteness of the ruling was not an accident. It was a decision. And the consequences of that decision are going to be playing out in American courts for a generation. Point 2. The Carroll post office immunity fight is the most consequential ongoing legal battle, and almost nobody is covering it adequately. Here is why the new Carroll Supreme Court petition that Trump's team is preparing as of May 2026 matters so much beyond just whether he has to pay $90 million in damages. The immunity ruling addressed what happens to a president's legal exposure for conduct taken while in office. It did not clearly address what happens to a president's exposure for conduct taken after leaving office, particularly conduct that relates to or flows from things that happened during the presidency. If the Supreme Court agrees to hear Trump's Carroll appeal and extends the immunity framework to cover at least some post-office presidential conduct, the implications go far beyond Trump. They would mean that every future president has constitutional protection, not just for what they do in office, but potentially for what they say and do afterward, if it is connected to their presidential role. They would mean that civil plaintiffs who are harmed by presidential conduct, whether during or after a term, face an even higher bar to collecting damages. And they would mean that the scope of presidential legal accountability has been narrowed again by a Supreme Court that already narrowed it dramatically in 2024. If the court declines to hear the case, Carroll can proceed to collect her money, and the immunity ruling's reach is at least partially contained to in-office conduct. Either outcome has enormous consequences, and the decision about whether to take up the case could come at any time. Point 3. The dissent's warnings have proved prescient, and the legal community has started to say so openly. Here is what legal scholars and constitutional experts are increasingly acknowledging in academic journals and policy publications 2 years after the ruling. Justice Sotomayor's dissent, which called the president a king above the law and laid out hypotheticals about assassination, bribery, and coups, was not hyperbolic. It was a precise logical analysis of where the majority's framework leads if it is applied consistently and broadly. Georgetown law professor Steve Ledeck, who has been one of the most widely respected voices on this issue, said publicly that with every day that passes, the immunity ruling looks increasingly stunningly myopically naive. The Brennan Center called it unfounded in both history and legal precedent. Penn Law Review published academic analysis questioning whether the framework is sustainable as a matter of separation of powers doctrine. These are serious institutions making serious arguments. And the fact that they are making them more loudly and more specifically 2 years after the ruling, rather than less, suggests that the real-world consequences of the decision are becoming clearer and more alarming to people who think carefully about constitutional governance. The dissent warned that the ruling creates a law-free zone around the president. The evidence of the past 2 years and how the Trump administration has operated and how the DOJ has been used and how court orders have been treated has not contradicted that warning. It has reinforced it. Point 4. What happens next in the Supreme Court will define the outer limits of presidential immunity for a generation. Here is the biggest picture takeaway, and the one that matters most for understanding where American constitutional law is heading. The 2024 immunity ruling was the opening move in what is going to be a multi-decade legal conversation about the scope of presidential accountability. The court answered one set of questions about in-office official acts and left enormous territory unexplored. The Carroll case is about to bring a second set of questions back to the same court about post-office conduct, about the relationship between personal and official capacity, about how far the immunity framework extends beyond the specific factual context of the Trump v. United States case, and there will be more cases after that, as future presidents and former presidents invoke the ruling in their own legal disputes. As lower courts apply the framework to new factual situations and reach conflicting conclusions that the Supreme Court will eventually have to resolve. As Congress potentially responds with legislation trying to define or limit the immunity the court has established, the 2024 ruling was not the end of this constitutional story, it was the end of the beginning. The middle of this story, the part where the framework is tested, refined, extended, and contested, is happening right now. In the Carroll litigation, in the hush money appeal, in the academic debates being conducted in law journals, and in the ongoing political battles over what presidential accountability should look like in a country that was founded on the principle that no one, not even a president, is above the law. Whether that principle survives the immunity ruling intact or whether it has been permanently compromised is the question American democracy is trying to answer right now. And the answer is still genuinely uncertain. And speaking of uncertain answers, next video we are going somewhere that takes every thread of this immunity story and follows it directly to its most consequential endpoint. We are covering what happens if the Supreme Court takes up Trump's Carroll immunity petition, what the justices would actually be deciding, how a ruling in his favor would change the legal landscape for every future president, and whether there is any realistic path for Congress or the courts to put guardrails back on a framework that 3 Supreme Court justices call utterly indefensible. You are absolutely not going to want to miss that one.